Welcome to your exam prep journey, where we will build a robust framework for mastering the essential principles of federal fair housing law. This content is for informational and entertainment purposes only and does not constitute legal advice. This is an unofficial, independent study guide and is not affiliated with, endorsed by, or connected to any official real estate licensing board or exam provider. Always consult with a qualified professional or your state's regulatory agency before making legal or professional decisions. In this opening chapter, we are going to establish a clear roadmap for navigating the fair housing segment of the national real estate exam. By breaking down the regulatory requirements, we ensure that you can identify protected classes and prohibited behaviors with absolute certainty. Investing time in these foundational concepts now is the most effective way to guarantee your exam success. You will gain a comprehensive understanding of the legal landscape that governs every interaction in modern real estate practice. The fair housing portion of a national exam often catches candidates off guard because it requires both rote memorization and the ability to apply abstract legal standards to nuanced, real-world scenarios. We will begin by tracing the chronological evolution of housing legislation, starting with the Civil Rights Act of 1866 and moving forward to the landmark 1968 Fair Housing Act and its vital 1988 amendments. Understanding this historical progression is not merely an academic exercise, as the structure of these laws directly informs the questions you will see on the test. You will learn to identify the 7 federally protected classes and understand exactly how these legal definitions shield consumers from discrimination. This course is designed to make these complex mandates crystal clear, replacing vague concepts with sharp, actionable knowledge. Our approach prioritizes consumer protection and equitable access to housing, which serves both as the cornerstone of ethical practice and the key to passing your exam. As we progress through the curriculum, we will dissect the specific regulatory categories that carry the most weight in the exam room, such as the distinction between steering, redlining, and blockbusting. These prohibited practices are frequently the subject of complex situational questions that test your ability to maintain professional boundaries in the face of client pressure. We will also examine the severe consequences of noncompliance, ranging from significant monetary fines and civil litigation to the permanent revocation of your real estate license. Grasping these disciplinary mechanisms reinforces the importance of diligence and documentation in your professional career. You will walk away with a refined ability to spot discriminatory intent in both verbal communication and advertising materials. Achieving proficiency in these areas will shift your perspective from merely preparing for a test to internalizing the ethical obligations inherent in real estate brokerage. Cultivating the right mindset for this portion of the exam is just as important as reading the statutes themselves. Throughout this course, try to view every scenario through the lens of a neutral intermediary whose primary duty is to uphold equitable access to housing for every individual. When you remove implicit bias from your decision-making process and adhere strictly to the law, you not only pass the exam, but also set the standard for your future professional reputation. We will move systematically from one legal pillar to the next, ensuring that you understand the why behind each rule rather than just memorizing a list of constraints. This deeper level of comprehension ensures that even if a question is phrased in an unfamiliar way, you'll be able to apply the underlying legal principles to arrive at the correct answer. The dedication you show here will be the determining factor in your performance on exam day and in your subsequent career. Prepare yourself for a thorough exploration of federal and state jurisdictions, as understanding the boundaries between them is a common point of confusion for many test takers. We will refine your knowledge of professional ethics until you are capable of navigating difficult transactions with confidence and complete regulatory compliance. You are about to acquire the tools necessary to turn potentially intimidating legal topics into distinct, reliable advantages on your licensing exam. I look forward to walking this path with you as we sharpen your skills and solidify your understanding of these core real estate principles. Success in this field requires both technical mastery and a steadfast commitment to the regulations that define our industry. Let us begin this process of rigorous preparation and build the expertise that will serve you throughout your entire career. We will move directly to our first historical review in the next segment. See you in the following lecture. Welcome to our deep dive into the legislative foundations of fair housing, where we will specifically analyze the Civil Rights Act of 1866 and its enduring impact on real estate practice. The Civil Rights Act of 1866 represents the bedrock of fair housing legislation in the United States, enacted in the immediate aftermath of the Civil War to address the systemic exclusion of newly freed citizens from the property market. When you encounter questions about this statute on your national exam, you must remember that its scope is singular and absolute. It prohibits all discrimination based on race or color in the sale or rental of any real property, whether residential or commercial. Unlike the complex frameworks that would follow a century later, this act does not contain a list of protected classes. It focuses exclusively on racial equality. It provides a legal mechanism for private citizens to file lawsuits directly in federal court if they believe their rights under this act have been violated. This direct path to federal litigation remains one of the most powerful tools in civil rights enforcement because it bypasses the administrative processes often required by newer fair housing statutes. You should conceive of this law as a pervasive, overarching protection that operates independently of modern housing regulations. One of the most common pitfalls for students taking a national exam is conflating the 1866 Act with the Fair Housing Act of 1968. You must internalize the fact that the 1866 Act has absolutely no exemptions, whereas subsequent laws frequently allow for narrow circumstances where certain types of property owners may be exempt from specific guidelines. For example, a small owner-occupied dwelling or a private club might find relief under the 1968 Fair Housing Act. But those same parties have zero legal defense if they discriminate on the basis of race under the 1866 Act. This absolute prohibition means that even if a transaction involves a type of property that is traditionally exempt from modern fair housing scrutiny, the 1866 statute still applies if the alleged discrimination involves race. Consider this a fail-safe for the legal system, ensuring that racial bias can never be sheltered by the technicalities that might otherwise apply to other protected classes. As you parse exam questions involving scenarios with private landlords or small-scale investors, always pause to verify if the question specifically references race, as this triggers the 1866 protections regardless of other exemptions. The constitutional validation of this act is anchored in the landmark Supreme Court decision of Jones versus Mayer in 1968. Before this case reached the High Court, some practitioners debated the extent of the 1866 Act's application to private transactions. But the ruling clarified that Congress held the authority to prohibit all racial discrimination in private housing under the 13th Amendment. The 13th Amendment, which abolished slavery, was interpreted by the court to include the right to inherit, purchase, lease, sell, hold, and convey real and personal property. By affirming this, the Supreme Court effectively cemented the 1866 Act as the most powerful, unyielding piece of fair housing legislation on the books. This is an essential point for your exam because it establishes that racial discrimination in housing is fundamentally unconstitutional even in private, arm's-length dealings. When a test prompt asks about whether a private seller has the right to refuse a buyer based on race, your reasoning must lead you immediately to the 1866 Act and the Jones versus Mayer precedent. I will see you in the next lecture. Welcome back. In this lesson, we will examine the legislative architecture of Title VIII of the Civil Rights Act of 1968 and its profound impact on the real estate profession. The Fair Housing Act of 1968 emerged as a landmark legislative response to the systemic patterns of exclusion that long permeated the American real estate landscape. While the earlier Civil Rights Act of 1866 addressed racial discrimination in property rights, it lacked the administrative framework necessary for broad enforcement in private housing markets. Title VIII effectively closed this gap by establishing a clear federal mandate intended to provide for fair housing throughout the United States. The law explicitly prohibited discrimination based on race, color, religion, and national origin, shifting the burden from the individual victim to a comprehensive federal regulatory structure. As real estate professionals, you must understand that this law applies broadly to residential dwellings, including single-family homes, multi-unit buildings, and even vacant land designated for residential construction. The legislative intent was not merely to prevent blatant acts of exclusion, but to eliminate the subtle barriers that functioned to maintain residential segregation. By codifying these protections, Congress sought to ensure that the housing market remain an open field where all prospective buyers and tenants are judged on their financial qualifications rather than their identity. This foundational framework dictates that you cannot, under any circumstances, allow personal prejudices or external social pressures to influence your professional decisions regarding property access. The operational reach of the Act is extensive, particularly regarding the specific prohibited actions that remain central to your daily practice. You are explicitly forbidden from refusing to sell, rent, or negotiate for housing based on any of the protected classes, a prohibition that extends to anyone involved in a housing-related transaction. This includes not only the obvious act of denying an application, but also discriminating in the terms, conditions, or privileges of the sale or rental of a dwelling. Providing different services or facilities to someone based on their protected status is a clear violation of this provision. Furthermore, the Act strictly prohibits the practice of falsely representing that any dwelling is not available for inspection, sale, or rent when it is, in fact, available. This particular aspect of a law is designed to prevent the common practice of gatekeeping, where agents might steer specific clients toward or away from certain properties to maintain demographic homogeneity. You must ensure that every client is presented with an accurate assessment of the market and that you maintain consistent standards when interacting with all prospects. These prohibitions are not suggestions. They're the pillars upon which your license rests, and failure to adhere to them places your career in significant legal jeopardy. The role of the Department of Housing and Urban Development, or HUD, is critical to understanding how these mandates are enforced in the real world. HUD serves as the primary federal agency responsible for implementing and overseeing the provisions of the Fair Housing Act, providing the necessary oversight to ensure that market participants maintain compliance. When a complaint is filed, the agency initiates an administrative process designed to investigate the alleged discrimination, which may include interviewing witnesses, reviewing documents, and assessing brokerage internal policies. If the agency finds reasonable cause to believe that a discriminatory practice has occurred, it facilitates conciliation efforts to resolve the dispute or may proceed to a formal administrative hearing. This mechanism transforms the law from a static document into a dynamic influence that holds individual agents and brokerage firms accountable for their activities. It is important to realize that the administrative path is only one avenue for relief, as aggrieved parties may also choose to pursue civil litigation in federal court. Understanding this enforcement apparatus underscores the seriousness with which the federal government views violations, as the potential investigation path into your conduct can be both time-consuming and detrimental to your professional standing. As we continue to build your expertise throughout this course, remember that these principles are not isolated facts, but an integrated framework governing your behavior. Every transaction you participate in, from the initial consultation with a buyer to the final closing of a deal, must reflect an uncompromising commitment to these fair housing standards. The 1968 law persists as the primary foundation for modern practice, shaping how we handle financing procedures, marketing materials, and client interactions across the entire country. By keeping these rules at the forefront of your decision-making, you not only protect yourself from liability, but also contribute to the ethical integrity of our industry as a whole. You must constantly audit your own procedures to ensure that you are treating every participant with the consistency and respect required by law. As we proceed, we will look at how subsequent amendments expanded upon these original four protections to cover additional classes and how you might encounter these issues in practical, everyday scenarios. I look forward to discussing these expansions with you in our next session. Welcome to this session on the expansion of protected classes, where we focus on the legislative milestones that shaped modern fair housing standards. We are examining the impact of the legislative changes introduced in 1974. Prior to 1974, the Fair Housing Act primarily addressed discrimination based on race, color, religion, and national origin. It remained silent on the issue of sex-based discrimination, a gap that created significant hurdles for individuals attempting to secure housing. During this era, lenders and landlords frequently employed tactics that disadvantaged women, particularly those seeking financing independently. It was common practice for financial institutions to discount alimony or child support as legitimate income when determining a borrower's qualification for a mortgage. This structural bias effectively barred many single women and single-parent households from homeownership, regardless of their actual creditworthiness or financial stability. The legislative response to these systemic inequities arrived through the Housing and Community Development Act of 1974. By amending the existing framework to include sex as a federally protected class, the government formally prohibited discrimination based on gender in the sale, rental, and financing of housing. The inclusion of gender as a protected class is not one-sided, as it prohibits discrimination against both men and women in the housing market. In a professional context, this necessitates that agents discard any preconceived notions regarding the roles or financial capacities of applicants based on their gender. For example, a broker might encounter a scenario where a landlord expresses a preference for male tenants under the assumption that they will provide better property maintenance, or conversely, a preference for female tenants due to perceived neatness. Both assumptions constitute clear violations of the law because they use gender as a non-professional proxy for behavior or capability. Brokers hold a fiduciary duty to their clients, and this duty is fundamentally incompatible with discriminatory practices. As a supervisor, you are responsible for ensuring that every member of your team applies the same professional standards to all prospective clients. You must verify that your brokerage does not utilize advertising materials that signal gender preference, implicitly or explicitly, which might alienate a specific demographic. One of the more nuanced elements of this amendment concerns the intersection of gender and sexual harassment. The courts have interpreted the prohibition of sex-based discrimination to include sexual harassment, which is defined as unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. In housing, this often manifests as a landlord or building manager leveraging their position of power to demand sexual compliance in exchange for housing opportunities or the renewal of a lease. This behavior is categorically illegal and falls directly under the protections established by the 1974 amendment. Agents must remain vigilant and objective during lease negotiations, ensuring that no tenant is subjected to a different standard of treatment because of their gender. If an agent witnesses or becomes aware of such conduct from a property owner or coworker, they are ethically and legally obligated to address the issue, as failing to do so could result in liability for the entire brokerage. When analyzing potential fair housing violations in your exam, you should focus on objectivity and the neutrality of the terms offered to applicants. A common pitfall for candidates is failing to recognize how subtle biases infiltrate standard operating procedures, such as how an agent chooses to explain loan programs or property features. If an agent spends more time discussing financial assistance programs with a male client than with a female client, or assumes a female client requires a spouse's signature, they are engaging in discriminatory treatment. Every interaction must be documented and executed with consistency, ensuring that the same set of options and disclosures is presented to every individual. Remember that the law mandates equal access to credit and housing, meaning that the personal life or gender composition of a household has no bearing on their right to compete for a property. By focusing on these core principles of neutrality, you'll be well positioned to answer complex scenario-based questions in future assessments. I will see you in the next lecture. Welcome back. In this lecture, we examine the Fair Housing Amendments Act of 1988, a pivotal expansion of federal protections that fundamentally reshaped the real estate landscape. The Civil Rights Act of 1968 provided a solid baseline for anti-discrimination, but it left significant gaps regarding specific demographics that frequently faced exclusion. By 1988, legislators recognized that without explicit protection for families and individuals with disabilities, the housing market remained inherently unequal. The resulting amendments were not merely incremental changes. They introduced robust enforcement mechanisms that granted the Department of Housing and Urban Development broader authority to pursue claims. This shift effectively transformed fair housing from a reactive framework into a proactive regulatory environment where discriminatory behavior faced stiffer penalties. Understanding this evolution is essential because these specific additions, familial status and disability, are the most frequently litigated areas in modern real estate practice. When you see questions regarding protected classes on your exam, recall that this specific legislation provided the constitutional teeth required to make such protections actionable. Familial status is defined by federal law as one or more individuals under the age of 18 being domiciled with a parent or another person having legal custody. This protection also extends to pregnant women and individuals who are in the process of securing legal custody, such as during an adoption proceeding. The intent here is to prevent landlords or sellers from using the presence of children as a pretext for exclusion, a common practice prior to this act. For instance, a landlord cannot advertise a property as adults only or enforce restrictive rules that disproportionately prohibit children from using common recreational areas. While some might assume this allows households to override occupancy standards, the law still permits reasonable occupancy limits based on health and safety codes. Therefore, your task as a professional is to balance these occupancy guidelines with the absolute prohibition against discriminating against families with minor children. The inclusion of disability as a protected class, often referred to in the statutes as handicap, covers any physical or mental impairment that substantially limits one or more major life activities. This broad definition encompasses an extensive range of conditions, including hearing, mobility, and visual impairments, as well as chronic mental health conditions and HIV-related illnesses. The legislation distinguishes between two specific requirements: reasonable modifications and reasonable accommodations. A reasonable modification allows a tenant to make physical changes to their living space, such as installing grab bars or lowering kitchen counters, provided the tenant performs the work at their own expense and restores the unit if necessary. Conversely, a reasonable accommodation refers to a change in rules, policies, or practices, such as allowing a service animal in a building that maintains a strict no pets policy. These requirements necessitate that property managers remain flexible and prioritize the functional needs of the tenant over rigid internal procedures. Despite these sweeping protections, the Act provides a narrow carve-out for housing for older persons, which allows certain communities to exclude families with children. To qualify for this exemption, a development must strictly adhere to federal certification criteria, such as the requirement that at least 80% of the occupied units be occupied by at least one person 55 years of age or older. This exemption is not an arbitrary choice for a landlord. It requires the community to demonstrate an intent to operate as housing for persons 55 or older and to verify those occupancy percentages regularly. If a community fails to maintain these rigorous standards or lacks the necessary documentation, it loses the exemption and must comply with all familial status protections. Professionals must understand that exceptions to fair housing laws are extremely limited. If you are unsure whether a facility qualifies, you must always default to the rule of equal opportunity. See you in the next lecture. Hello, and let's turn our attention to the 7 federally protected classes that form the backbone of national fair housing regulations. Understanding these specific categories is not merely a rote memorization task. It is the fundamental framework upon which almost every fair housing question on your national exam is built. The Fair Housing Act, as amended, specifies 7 protected classes that you must be able to identify without hesitation when analyzing any real estate transaction or scenario. We break these down into race, color, religion, national origin, sex, familial status, and disability. While many states choose to extend these protections to include characteristics like sexual orientation, source of income, or age, your national exam strictly adheres to these 7 federal categories. When you encounter a question regarding a protected class, you must discipline yourself to filter out any state-specific nuances that might lead you to stray from federal law. Focusing exclusively on this list ensures you remain grounded in the legal requirements that serve as the standard across the entire country. Race and color are distinct yet frequently misunderstood categories that often overlap in real-life scenarios but carry different legal implications. Race refers to a person's ancestry or physical characteristics associated with their racial group, while color pertains specifically to the shade of a person's skin. Discrimination based on color can occur even among members of the same race, which is a detail that occasionally shows up in exam vignettes to test your precision. Religion is another straightforward category, yet it requires a broad interpretation that includes all aspects of religious observance and practice, not just established institutional worship. You must treat any sincerely held religious belief with the same level of protection under the law, regardless of whether it aligns with popular or minority views. National origin refers to the country where a person was born or the country from which their ancestors originated. This is often confused with citizenship status, but it is vital to remember that the law protects individuals based on their national origin regardless of their legal status as a citizen. The category of sex was added as a protected class through the Housing and Community Development Act of 1974 to ensure that gender-based obstacles in housing acquisition were removed. Familial status is a more nuanced category that protects families with children under the age of 18, as well as pregnant women or individuals in the process of securing legal custody of a child. This classification is designed to prevent landlords or sellers from implementing arbitrary policies that exclude families, such as unreasonable occupancy restrictions or bans on children in specific buildings. It is important to remember that this protection is specifically focused on the presence of minors, and it does not typically protect households based solely on the age of the adults living there. When you see a scenario involving a family being denied housing because they have children, you should immediately recognize the involvement of familial status protections. Ensuring that landlords do not discriminate against these groups is a core component of maintaining equitable housing access across the national market. The final category, disability, is perhaps the most complex and expansive of the 7, as it covers both physical and mental impairments. A crucial, often overlooked aspect of this law is its protection of individuals who are recovering addicts, specifically those recovering from chemical dependencies. Provided the individual is not currently using illegal drugs, they are legally protected under the disability provision, and this status is a common target for exam questions designed to test your knowledge of the law's reach. The definition of a disability is an impairment that substantially limits one or more major life activities, and it includes individuals who have a record of such an impairment or are regarded as having such an impairment. It does not, however, protect individuals who are active users of illegal controlled substances. Identifying this distinction is essential because an agent must understand when an owner is prohibited from refusing a lease based on a person's history of treatment or recovery. Being able to correctly categorize these various individuals under the umbrella of federal law is what will allow you to navigate the exam with a high degree of technical accuracy. See you in the next lecture. Hello again. Let us examine the limited scenarios where the Fair Housing Act does not mandate full compliance. We will analyze the specific exemptions granted by federal law and the strict boundaries surrounding them. The Fair Housing Act provides a framework that is generally quite broad, covering nearly all residential real estate transactions in the United States. However, legal definitions occasionally carve out narrow spaces where federal oversight is relaxed, provided specific conditions are met. It is essential to recognize that these exemptions are the exception, not the rule, and they rely heavily on the absence of professional intermediary involvement. If you're a licensed real estate professional, you're almost never shielded by these exemptions because your participation fundamentally changes the nature of the transaction. The moment a broker or licensee enters the process, the playing field levels into full compliance with federal law, regardless of the property type or owner status. One of the most frequently misunderstood provisions is the Mrs. Murphy exemption, which applies to owner-occupied dwellings containing no more than 4 units. In such an arrangement, the owner resides in one of the units and rents out the others to tenants. The legislative intent here acknowledges a level of personal privacy in sharing one's own living space, which is why the law allows the owner some discretion that would otherwise be illegal. However, this logic evaporates if the owner engages a real estate agent to find a tenant or publishes an advertisement that indicates a discriminatory preference. Even in this narrow window, the exemption is stripped away the moment the transaction moves into the professional marketplace, where discriminatory barriers are prohibited. Another category of exemptions pertains to single-family housing sold or rented without the use of a real estate broker or agent. The statute allows an individual property owner to sell or lease their own home without adherence to the full weight of the act, provided they do not own more than 3 such houses at any one time. This does not grant a blanket license to discriminate, as the criteria for this exemption are quite rigorous and easily forfeited. If the owner uses a real estate professional to manage the sale or rental, the exemption is nullified instantly. Furthermore, any advertisement for the property must be devoid of discriminatory language, as the publication of such content acts as a trigger for federal oversight, effectively overriding the exemption entirely. Housing operated by private religious organizations or clubs constitutes a distinct class of exemptions, though these are limited to non-commercial purposes. A religious organization may provide housing to its own members without violating the fair housing laws, provided that the housing is not operated for a commercial gain. Similarly, private clubs that provide non-commercial lodging to their members are permitted to restrict access based on club membership, provided the club is not operating with a purely commercial motive. These structures are viewed as extensions of the organization's internal association rights rather than commercial real estate enterprises. The key takeaway for your exam purposes is to scrutinize the nature of the organization and ensure no commercial transactional activity is polluting the exempt status of the arrangement. We must discuss a critical, overarching constraint that applies to every single exemption described above: race. The Civil Rights Act of 1866 creates an absolute prohibition against discrimination based on race in all real estate transactions, without exception. This means that even if a transaction correctly falls under the Mrs. Murphy exemption or the private owner exemption, the owner cannot choose to discriminate on the basis of race. While the Fair Housing Act of 1968 allows for limited leniency, it cannot and does not repeal the 1866 Act's mandate regarding racial equality. Any attempt to use an exemption as a shield for racial exclusion will fail legally and will result in significant liability for the offending party. When analyzing these scenarios for your exam, always look for the involvement of a licensee or the presence of discriminatory advertising. If you see the words licensed real estate agent or professional listing in the question, the exemption is effectively off the table, and you should evaluate the case based on full federal compliance. The same result occurs if the scenario mentions an advertisement that specifies a protected class exception, as such an advertisement destroys the exemption from the start. Think of the exemptions as delicate legal privileges that are easily discarded through professional participation or public solicitation. By identifying whether a licensee is present or if advertising was used, you will find the correct answer in virtually every scenario-based question you encounter. I will see you in the next lecture. Welcome to this chapter on prohibited practices, where we will examine the specific conduct that undermines fair housing mandates. We begin by dissecting the mechanics of steering and how it manifests in professional real estate practice. Steering is defined as the illegal practice of channeling prospective buyers or renters toward or away from specific neighborhoods, housing developments, or geographic areas based on their membership in a protected class. It fundamentally alters the freedom of choice that a consumer is entitled to exercise when seeking housing. When an agent unilaterally decides that a client would be better served in a certain neighborhood because of their race, religion, or familial status, they're substituting their own biased judgment for the client's agency. This behavior does not require an explicit statement of racial preference to be deemed illegal. It can often masquerade as expert guidance or helpful localized advice, yet its core purpose is to maintain or create demographic homogeneity. By limiting where a client looks based on their background, an agent effectively enforces segregation and undermines the spirit of equal housing opportunity. Consider the scenario where an agent only shows a minority buyer homes in areas with high concentrations of that same minority group. Even if the agent believes they are helping the buyer feel more comfortable or welcome, the action remains a severe violation of the Fair Housing Act. Similarly, if an agent suggests to a family with children that they should focus exclusively on a specific neighborhood, described as kid-friendly, they are engaging in illegal steering based on familial status. These actions strip the housing consumer of the ability to make an informed decision based on their own personal preferences, budget, and lifestyle needs. The sociological impact of such practices is profound, as it perpetuates historical patterns of community segregation and artificially restricts the natural integration of our cities and suburbs. When agents treat clients according to stereotypes rather than individual merit, they degrade the professional integrity of the entire real estate industry. A critical concept for your exam is that the subjective intent of the agent is largely irrelevant when evaluated by the Department of Housing and Urban Development. You might feel that your actions are well-intentioned or that you are simply trying to save time for both parties. But if those actions have a discriminatory effect, the law views them as violations. HUD utilizes a process involving testers to identify these patterns in local markets, effectively checking if an agent provides different information or opportunities to different groups. If an agent steers persons in one protected class toward areas that differ significantly from those recommended to another group, they have failed the test. You must learn to distinguish between providing public, factual data about schools or transit and offering subjective opinions about who would be a good fit for a neighborhood. Any commentary that implies a correct demographic for a specific location is a red flag that will lead to severe disciplinary consequences. Legal consequences for engaging in steering can be extensive, often involving significant civil penalties, the loss of your professional license, and potential litigation from affected parties. Regulatory bodies frequently look for evidence of disparate treatment, which is evidenced by inconsistent service patterns over a period of time. To protect yourself and remain compliant, your focus must stay strictly on the financial and physical requirements of the property, such as square footage, room count, and price point. Allow the client to define their geographic focus and prioritize their own search parameters without your editorializing on the cultural makeup of the community. In every interaction, you should document the reasons for the property recommendations you make to ensure that your practice remains objective and transparent. Mastery of these distinctions is vital for passing the exam and maintaining your standing as a professional advisor in the field. We will resume our analysis of prohibited conduct in our next session. Welcome back. Today, we will examine the mechanics of blockbusting and why it remains a strictly prohibited practice in professional real estate. Blockbusting, which is interchangeably referred to as panic selling, describes a coercive tactic where a real estate professional or speculator deliberately induces homeowners to sell their properties by playing on racial or socioeconomic fears. Historically, unscrupulous speculators would approach residents in a neighborhood and suggest that the imminent arrival of a protected class of people would lead to a catastrophic decline in local property values or a general erosion of neighborhood quality. This strategy was designed solely to create a sense of urgency and panic, allowing the speculator to purchase homes at artificially deflated prices before reselling them at a significant profit to members of the very group that the residents have been taught to fear. From an economic perspective, there is no evidence to support the claim that the entry of any protected class into a neighborhood causes property values to drop. In reality, such claims are transparent fallacies intended to manipulate homeowners into making irrational financial decisions based on prejudice rather than facts. This practice is not only ethically reprehensible, but is a direct violation of the Fair Housing Act, which seeks to prevent the artificial destabilization of communities through discriminatory market manipulation. When you encounter questions regarding this topic on the national exam, you must learn to recognize the subtle nuances of these manipulative tactics. The core violation is the attempt to influence a listing decision by suggesting that the racial, religious, or ethnic composition of a neighborhood is shifting or will shift in the near future. It does not matter if the real estate agent makes this claim directly or merely implies it through leading questions or suggestive comments. Even a casual remark linking the demographics of a neighborhood to the current marketability or value of a home can be interpreted as a blockbusting attempt under federal law. For example, if an agent tells a client they should sell now while they still can because certain people are moving into the area, that agent is engaging in illegal panic selling. The exam will often present scenarios that appear to be innocent market advice, but contain these specific markers. You must be able to filter out the noise and identify this prohibited behavior as an illegal interference with the property rights of the homeowner. As a professional, your role is to provide neutral, fact-based market analysis that remains completely divorced from the protected status of any current or potential residents. Stability in the housing market is maintained when agents focus on objective metrics like square footage, recent comparable sales, and local economic conditions rather than fear-mongering and demographic speculation. If you ever feel that a client is asking for a market valuation based on the demographic composition of their street, you must pivot the conversation back to the actual data. Maintaining this standard is not just about avoiding legal repercussions or fines. It is about upholding the professional obligation to treat all clients and neighborhoods with fairness and dignity. By focusing exclusively on the property and objective financial metrics, you protect yourself from liability and contribute to the legal mandate that housing must remain accessible and free from discriminatory churn. Remember that any attempt to create a selling motive based on the influx of a specific group is, by definition, a hallmark of an illegal practice. I look forward to our next discussion as we continue through this material. Welcome back. In this lesson, we will examine the history and mechanics of redlining, while detailing the legislative frameworks designed to prevent discriminatory lending practices in our communities. Redlining refers to the systemic denial of mortgages, insurance, or other financial services to residents within specific geographic areas, typically based on the racial or ethnic composition of those neighborhoods rather than the financial qualifications of the individual applicant. Historically, this practice involved lenders literally drawing red lines on maps to designate regions they considered too risky for investment, effectively isolating minority communities from the benefits of homeownership. This creates a feedback loop where property values stagnate, infrastructure investment declines, and the generational wealth that typically accumulates through home equity is permanently stifled for entire populations. You must understand that even if a borrower has excellent credit and a stable income, a lender's decision to deny a loan based solely on the property's location in a designated zip code or neighborhood is a clear violation of fair housing principles. Real estate professionals often encounter exam scenarios where a lender refuses to finance a property in a changing neighborhood, and you must recognize this behavior as redlining rather than legitimate risk management. The consequence of these actions is not only illegal, but also fundamentally destructive to the principles of fair market participation that our laws are designed to protect. To combat these patterns of discrimination, the federal government enacted the Home Mortgage Disclosure Act, commonly referred to as HMDA. This legislation requires financial institutions to maintain and publicly disclose data regarding home mortgage applications, including the location of the properties being financed. By aggregating this loan data, regulators can identify geographic patterns of lending, which makes it significantly harder for institutions to mask discriminatory practices behind neutral-sounding policies. If the data shows that a specific institution is consistently rejecting applications in minority-heavy census tracts while approving similar ones elsewhere, regulators use this as evidence to investigate potential redlining. HMDA essentially acts as the sunlight that exposes shadow-based lending behaviors, forcing transparency upon institutions that might otherwise prefer to operate without public scrutiny. As a future licensee, you should view HMDA not just as a bureaucratic reporting requirement for banks, but as a critical tool that ensures institutional compliance with the Fair Housing Act and the Equal Credit Opportunity Act. Parallel to the efforts of HMDA, the Community Reinvestment Act serves as a regulatory mandate requiring financial institutions to meet the credit needs of the entire community in which they are chartered. This act specifically discourages lenders from taking deposits from a specific area while simultaneously refusing to extend credit or investment back into those same areas. Unlike laws that focus solely on prohibiting bad behavior, the Community Reinvestment Act mandates affirmative action by requiring lenders to demonstrate that they are actively providing banking services to low and moderate income populations. Regulators evaluate a lender's performance under this act and assign a rating that can impact the bank's ability to open new branches, merge with other institutions, or expand their service offerings. This ensures that the responsibility of the financial sector is aligned with the health of the broader local economy rather than just the interests of wealthy, low-risk enclaves. When you analyze exam questions about lending obligations, remember that federal law expects banks to be active, inclusive participants in the economic life of every neighborhood within their service area. Recognizing the impact of these practices requires you to look beyond individual transactions and consider the systemic effects on urban development. When capital is systematically drained from a neighborhood, the resulting disinvestment leads to a decline in school funding, public services, and commercial growth, which further accelerates the downward cycle the practice originally claimed to be avoiding. You must be able to distinguish between legitimate underwriting standards, which rely on the applicant's debt-to-income ratio and credit history, and illegal redlining, which is predicated on the identity of a neighborhood. An exam question might describe a situation where a loan officer expresses hesitation about a property because the area is in flux or the demographic profile of the area is shifting. Your task is to identify that such comments are red flags indicating a potential violation of fair housing laws. By maintaining a focus on individual merit and refusing to participate in geographic bias, you help uphold the integrity of the housing market while protecting the rights of all potential buyers. See you in the next lecture. Welcome back. We are now turning our attention to the specific legal constraints surrounding advertising and marketing tactics in real estate. This chapter explores exactly how to craft compliant promotional material while avoiding the common traps that lead to federal violations. When we examine the Fair Housing Act, we must understand that the prohibition against discriminatory advertising is absolute. Section 804(c) explicitly makes it unlawful to print, publish, or cause to be made any advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, religion, sex, handicap, familial status, or national origin. This applies to the entire marketing spectrum, from digital listings in newspapers to social media posts, and even the visual aids you choose for a brochure. The law does not focus on your intent as the advertiser, but rather on the message received by the average reader. If a reasonable person would interpret your ad as excluding members of a protected class, you have likely crossed the line into illegal conduct. This standard is rigorous because it protects the integrity of the housing market, ensuring that anyone capable of purchasing or leasing a property has equal access to information about it. To remain compliant, we must treat the concept of a protected class as a binary toggle in our marketing vocabulary. You cannot use words or phrases that suggest a preference for or against any protected category, even if you believe the intent is benign or descriptive. Phrases like perfect for couples or ideal for a single professional frequently appear on exams as examples of illegal content because they indicate a preference related to familial status or marital status. While the latter is not a federal protected class under the Fair Housing Act specifically, linking housing suitability to household composition often triggers a violation of the familial status protections. Similarly, stating a property is walking distance to a synagogue suggests a preference for a specific religion, regardless of whether the proximity was intended as a convenience. You must focus your advertisements strictly on the property features and amenities, such as square footage, number of bedrooms, or modern upgrades, rather than the lifestyle preferences of perceived occupants. Visual aids carry the same legal weight as your copy, which necessitates a sober approach to photography and graphic design. If you use human models in your flyers or video tours, those models must represent the inclusive diversity of the community at large. Consistently using models who belong only to one specific demographic implies a clear preference, which constitutes a discriminatory act under HUD guidelines. Furthermore, the use of symbols, such as religious imagery or flags associated with specific national origins, can be construed as creating a barrier to entry for those outside those groups. When placing your advertisements, you must also be mindful of your media strategy, as steering your marketing efforts exclusively towards certain newspapers or social media groups that cater to a single race or nationality is considered a violation of the law. You are obligated to promote your listing to the general public to ensure that no group is systematically excluded from the opportunity to inquire about the home. Perhaps the most dangerous misconception you will encounter, and a frequent trap on your national exam, is the idea that certain exemptions to the Fair Housing Act grant you a pass on advertising rules. For instance, you might assume that if a property is exempt under the Mrs. Murphy exception or another specific exemption, you're free to advertise preferences as you see fit. This is fundamentally incorrect, as the prohibition regarding discriminatory advertising is one of the few provisions that applies universally. Even if the property owner is not required to comply with other sections of the Act, they are still strictly forbidden from publishing advertisements that discriminate based on race, color, religion, sex, handicap, familial status, or national origin. The law insists that no form of discriminatory communication be disseminated in the housing market, creating a zero-tolerance policy that transcends any individual property exemptions. Including the Equal Housing Opportunity logo or the legend Equal Housing Opportunity in all print and digital media is your baseline requirement to signal your commitment to these standards. See you in the next lecture. Welcome back to our technical exploration of fair housing standards. We are turning our focus toward the nuances of familial status, specifically how occupancy standards often intersect with potential discriminatory practices. Familial status was added as a protected class under the Fair Housing Amendments Act of 1988, which explicitly prohibits discrimination against families with children under the age of 18. Discrimination in this context frequently manifests through restrictive occupancy standards intended to limit or exclude such families from a property. While a landlord has a legitimate interest in limiting the number of occupants to prevent wear and tear or excessive utility usage, these policies must be applied uniformly and reasonably. A critical piece of guidance in this field is the Keating Memorandum, issued by HUD, which clarifies that occupancy policies should generally not be used to restrict children. The common rule of thumb often cited is the 2 persons per bedroom standard, though this is not a federal mandate or a safe harbor clause that protects a landlord from a discrimination claim. If a landlord enforces a policy more restrictive than this, they bear the burden of proving that their restriction is based on objective factors rather than a desire to exclude families. When we examine the reasonableness of occupancy standards, we must look beyond just the bedroom count. Courts and HUD investigators consider the total square footage of the unit, the age of the children, and the physical configuration of the apartment. For instance, a small unit might legitimately accommodate fewer people, but a landlord cannot arbitrarily state that a family with a child is ineligible if the physical space is sufficient. Furthermore, landlords must be cautious regarding how they regulate the use of common areas. Attempting to ban children from pools, gyms, or designated floors creates a direct violation of the Fair Housing Act by treating households differently based on familial status. These rules are often disguised as safety regulations, yet if they impose a blanket prohibition against children rather than restricting specific high-risk behaviors, they are typically deemed unlawful. The Housing for Older Persons Act, or HOPA, provides a narrow exception to the prohibition against familial status discrimination by allowing certain communities to legally exclude families with children. To qualify for this exemption, a community must satisfy strict criteria to be classified as housing for older persons. Specifically, projects intended for residents 62 years of age or older must ensure that all residents meet this age requirement, save for limited personnel or visitors. For communities geared toward those 55 and older, at least 80% of the occupied units must have at least one occupant who is 55 years of age or older, and the facility must publish and adhere to policies that reflect this intent. These HOPA communities must also demonstrate compliance through verifiable surveys and documentation to maintain their exempt status. If a community fails to meet these rigorous data-driven standards, it loses its exemption and must permit families with children to reside there just like any other residential property. Determining the legality of an adults-only policy requires a disciplined look at whether that policy serves a legitimate, non-discriminatory purpose or if it functions as a pretext for exclusion. Real estate professionals must be able to distinguish between reasonable facility management, like limiting the number of occupants for safety reasons, and systemic bias that unfairly targets families. If a landlord imposes a rule that effectively denies housing to families with children, the lack of a clear, objective rationale will almost certainly be viewed as a violation of federal law. As we analyze these scenarios, Remember that the law prioritizes the right of families to access housing over the convenience or preferences of a property owner. Developing a clear understanding of these boundaries is not just about passing an exam. It is fundamentally about ensuring compliance in a high-stakes professional environment. I will see you in our next session. Welcome back to our exploration of federal housing mandates, where today we focus specifically on the nuances of reasonable accommodations and physical modifications. Understanding the distinction between these two concepts is fundamental for any professional ensuring compliance with the Fair Housing Act and the Americans with Disabilities Act. To understand the legal obligation, we must first distinguish between an accommodation and a modification. A reasonable accommodation refers to a change in rules, policies, practices, or services that is necessary to afford a person with a disability an equal opportunity to use and enjoy dwelling. Think of this as a procedural shift rather than a structural one, such as granting an exception to a no-pets policy to allow a tenant to keep an emotional support animal. The landlord generally cannot charge a fee for this accommodation, as it does not fundamentally alter the nature of the housing provider's operations. On the other hand, a reasonable modification is a structural change made to the physical premises to allow a person with a disability full enjoyment of their living space. Examples include widening doorways, lowering kitchen cabinets, or installing a permanent ramp at an entrance. When considering who pays for these changes, the financial responsibility often depends on the type of housing and when it was constructed. Under the Fair Housing Act, tenants in private rental housing are generally responsible for the costs associated with reasonable modifications. However, in multifamily dwellings built for first occupancy after March 13, 1991, the developer must have ensured the design met specific accessibility standards, meaning some features should already be in place. If a tenant is permitted to make structural modifications, the landlord may require the tenant to pay into an interest-bearing escrow account to cover the costs of restoring the unit to its original condition upon move-out. This restoration requirement specifically applies when a modification would interfere with the next tenant's use of a unit, such as removing a ramp that might obstruct a walkway, though it rarely applies to features like widened doorways or grab bars. Service animals and emotional support animals are frequent subjects of confusion in professional practice. A service animal, typically a dog, is trained to perform specific tasks for an individual with a disability, whereas an emotional support animal provides comfort and does not necessarily require individualized task training. Under federal law, housing providers may ask two specific questions if the disability-related need for an animal is not readily apparent. Is the animal a service animal required because of a disability, and what work or task has the animal been trained to perform? You cannot request documentation of the individual's disability or demand that the animal wear a vest or certification tag. Keep in mind that housing providers must offer these accommodations unless doing so would impose an undue financial and administrative burden, or if it would fundamentally alter the housing provider's operations. When you encounter scenarios involving these requests, your primary concern is recognizing the landlord's obligation to facilitate equal access. A request for an accommodation shouldn't be denied simply because the landlord operates under a strict policy, such as a prohibition against pets. The law specifically overrides default lease language when an accommodation or modification is necessary for someone with a disability to enjoy their home. As a licensee, your role is to facilitate the conversation between the tenant and the landlord, ensuring that both parties understand their rights and obligations under the framework of reasonable standards. Maintain a focus on the necessity of the request and the consistency with which policies are applied, which builds a strong defense against potential claims of discrimination. See you in the next lecture. Hello. Let us look at the administrative process for filing a housing discrimination complaint. We will explore how HUD handles an allegation from intake to resolution. When an individual believes they have been a victim of housing discrimination, The Department of Housing and Urban Development, or HUD, provides a formal administrative pathway for redress through the Office of Fair Housing and Equal Opportunity. This process is initiated when an aggrieved party files a complaint, which must occur within 1 year of the alleged discriminatory act. It is important to distinguish this administrative timeline from the alternative route of filing a private civil lawsuit in federal district court, which allows a 2-year statute of limitations. Once a complaint is submitted, HUD performs an intake assessment to determine whether the agency has jurisdiction over the matter and if there is sufficient information to warrant a formal investigation. If the complaint falls within the scope of the Fair Housing Act, the agency moves forward to gather evidence from both the complainant and the respondent. Throughout this initial phase, the burden rests on the complainant to establish what we refer to as a prima facie case of discrimination. This means they must provide enough initial evidence to support the claim that a prohibited practice occurred, which then shifts the burden to the respondent to offer a legitimate, non-discriminatory reason for their actions. After the investigation begins, HUD prioritizes the conciliation phase as a primary method for resolving these disputes. Conciliation is a voluntary process where HUD acts as a neutral party to facilitate an agreement between the complainant and the respondent without the need for a full adversarial hearing. If both parties reach a mutually acceptable resolution, the terms are formalized in a conciliation agreement, which is signed by the parties and approved by the department. Should the respondent fail to uphold the terms of this agreement, the matter may be referred for enforcement action to ensure compliance. It is essential to understand that this phase is designed to be restorative rather than purely punitive, aiming to rectify the specific harm caused by the alleged violation. Real estate professionals should recognize that being cooperative during this stage is generally more favorable than allowing the process to escalate into formal litigation. The focus remains on settling the issue before it reaches the desk of an official presiding authority. If conciliation efforts fail and the investigation produces evidence suggesting that a violation of the Fair Housing Act indeed occurred, HUD may issue a charge of discrimination. At this pivotal juncture, the case is assigned to an administrative law judge, or ALJ, to conduct a formal hearing. Unlike the conciliation phase, this stage is adjudicatory and carries much higher stakes for the respondent. The ALJ has the authority to award actual damages to the aggrieved party, impose civil penalties to vindicate the public interest, and issue injunctive relief to stop the discriminatory conduct. A crucial detail to remember for your exam is that the ALJ's decision is a binding administrative order, though it can still be appealed to the appropriate federal court. This administrative structure ensures that the federal government can enforce fair housing mandates, even when a private plaintiff chooses not to pursue their own independent civil action. Understanding this distinction between the informal resolution process and the formal judicial process is a fundamental requirement for any practitioner navigating the regulatory landscape of real estate. See you in the next lecture. Welcome back. In this lesson, we will examine the financial and professional consequences that follow when federal fair housing laws are breached. When a violation of the Fair Housing Act occurs, the legal system employs a tiered approach to civil penalties that is specifically designed to escalate based on the recidivism of the offender. Administrative law judges are granted the authority to impose these fines, which are adjusted annually for inflation to ensure they remain a potent deterrent against discriminatory practices. For a first offense, the maximum fine is substantial, but it increases significantly if the respondent has been found guilty of prior violations within a specific 5-year or 7-year window. This structured escalation makes it clear that the regulatory framework views repeat offenses with extreme severity. Beyond these civil penalties, the victim is frequently awarded compensatory damages to cover actual out-of-pocket expenses incurred due to the discrimination. These costs might include temporary housing, storage fees, or the difference in price for a comparable rental unit if the victim was improperly denied a lease. It is important to remember that these payments are restorative in nature aiming to make the victim whole again after the harm they have endured. In addition to the costs associated with financial loss, courts may award damages for emotional distress, which compensate the victim for the humiliation, embarrassment, and mental anguish caused by the Discriminatory Act. While civil penalties handled by administrative bodies focus on regulatory compliance, federal court cases can result in the assessment of punitive damages. These are not intended to compensate the victim for a specific loss, but rather to punish the wrongdoer and signal to the public that such conduct is intolerable. The unpredictable nature of punitive awards serves as a massive financial risk for brokers and agents alike. Furthermore, the doctrine of respondeat superior looms large over every brokerage office. This legal principle dictates that a broker is vicariously liable for the discriminatory acts of their affiliated licensees, even if the broker had no personal knowledge of the specific incident. Because the broker is often the one with the financial resources to satisfy a judgment, they become the primary target for litigation, placing an immense burden on the brokerage to maintain aggressive oversight and internal compliance protocols. The professional repercussions are often far more permanent than the financial ones, particularly regarding one's standing with state licensing authorities. Every real estate license is a privilege granted based on the premise that the licensee will adhere to established standards of conduct, including the federal mandate to provide equal opportunity in housing. When a fair housing violation is confirmed, the state real estate commission or department takes the matter as a direct strike against the integrity of the profession. This can lead to the mandatory suspension of a license for a set period, effectively removing the agent from the marketplace during that term. In cases involving patterns of discriminatory conduct or egregious violations, the state authority has the legal mandate to pursue permanent revocation. Once a license is stripped, the individual is generally barred from re-entering the industry, which effectively ends their career in real estate regardless of past successes or high sales volume. Managing these risks requires a shift in perspective from viewing fair housing as a theoretical set of rules to treating it as the central pillar of risk management. Because you're legally tied to the actions of those you supervise or work alongside, you cannot afford to be passive regarding office culture or standard operating procedures. The financial viability of a brokerage depends on the strict avoidance of these violations, as the cost of a single lawsuit or government investigation can exceed the annual commissions of many small offices. By understanding that these penalties are designed to be punitive, progressive, and professionally debilitating, one can see why strict adherence is the only logical course of action. Every transaction must be documented with the intention of demonstrating, if challenged, that every client was treated with the exact same level of service and professional rigor. I will see you in the next installment. Welcome to our exploration of testing, a critical mechanism used to identify and prosecute discriminatory practices in real estate. We will analyze the methodologies of these investigations and explain why consistent service is your only structural safeguard. In the context of fair housing enforcement, a tester is an individual who poses as a prospective buyer or renter to obtain first-hand information about the way a real estate professional interacts with the public. These individuals are typically deployed by local, state, or federal agencies, as well as private nonprofit fair housing organizations, to ensure statutory compliance. The primary objective is to determine if a housing provider treats potential clients differently based on their membership in a protected class, such as race, color, religion, sex, disability, familial status, or national origin. The tester does not represent a real client and is not attempting to purchase or rent a property in good faith. Instead, they act as an investigative tool, essentially auditing the service provided to see if it conforms to the strict requirements of the Fair Housing Act. When conducting these audits, testers follow a predetermined script to maintain a controlled environment, ensuring that the only variable that changes between different interactions is the protected characteristic of the applicant. This methodological rigor is precisely what gives the results legal weight in an administrative or judicial setting. The admissibility of evidence gathered through testing has been firmly established in United States courts, most notably through landmark Supreme Court decisions, such as Havens Realty Corporation v. Coleman. In this case, the court recognized that testing is a permissible method for identifying prohibited discriminatory conduct, and that testers have standing to sue for violations of the Act. The legal logic here is that if a real estate professional provides different information regarding availability, terms, or conditions of a sale or lease based on the applicant's background, this constitutes an injury. Because the evidence is generated in a controlled manner, it allows courts to compare the experiences of different testers who present identical financial and personal profiles but belong to different protected groups. This comparison creates a window into the professional's operational habits, stripping away the subjectivity of verbal claims. Even if a broker or agent claims they did not harbor overt prejudice, the findings from these tests serve as an objective baseline to demonstrate, through statistical or comparative evidence, whether disparate treatment occurred in practice. As a real estate licensee, you must understand that passing a test is not about gaming a system, but about maintaining absolute consistency in every interaction with every consumer. If you tell one prospect that a property is sold out, but inform a subsequent prospect that units are available, you have potentially created a record of discriminatory behavior. This holds true even if your intentions were benign, or if the mismatch was a result of a simple clerical error or a lack of attention to detail. Documentation and standardized procedures become your most reliable defense in these scenarios. You should implement a system where all inquiries are logged and all prospects are given the same packet of information, regardless of their demographic variables. When you provide the exact same facts, financing options, and property availability status to everyone, you remove the opportunity for an investigator to find a discrepancy. Consistency acts as an immunization against allegations of bias, ensuring that your business practices remain inherently defensible under the scrutiny of an audit or an official investigation. The mechanics of a suspected violation often rely on subtle differences in treatment rather than overt refusal of service. For example, an agent might offer to show a white prospect several homes in a specific area, while offering a minority prospect only homes in neighborhoods with a high concentration of that specific minority group. While the agent may not explicitly state their reasons, the pattern of behavior, when observed and recorded by testers, reveals steering. Similarly, an agent might quote different loan terms or mention incentives to one person but withhold that same information from another. Because testers record these interactions, the evidence does not rely on hearsay or the potentially flawed memory of a client. By maintaining a professional standard that requires providing every client with the same objective data, you eliminate the legal exposure created by individualized or inconsistent service. Being aware that these processes exist and understanding the legal weight they carry serves as a powerful incentive to refine your internal policies regarding client communication and property disclosure practices. Understanding the nature of testing allows you to build a more compliant and ethical professional foundation. See you in the next lecture. Hello, and welcome back to our discussion on fair housing enforcement and the critical legal concepts governing real estate practices. In this lesson, we will delve into the distinction between disparate treatment and disparate impact, two concepts that every licensee must master to avoid legal liability. When we talk about disparate treatment, we are discussing intentional conduct, which is the most classic and straightforward form of discrimination in real estate. This occurs when a licensee treats a client or an applicant differently because of their membership in a protected class, such as race, color, religion, national origin, sex, disability, or familial status. If you tell a buyer of a certain ethnic background that a house is not available, while simultaneously showing that same house to another buyer, you have engaged in disparate treatment. This is actionable because the intent to discriminate is clear and the action taken is directly linked to the protected characteristic of the individual involved. It is an active, conscious decision to deny equal housing opportunity, and the courts treat this type of infringement quite harshly because it violates the fundamental promise of the Fair Housing Act. From a professional standpoint, avoiding such conduct is usually a matter of adhering to a strict, non-discriminatory policy that applies to every single client in exactly the same way. The legal burden here is typically on the plaintiff to prove that the defendant acted with a discriminatory motive or intent, which can sometimes be demonstrated through documentation, witness testimony, or patterns of behavior that reveal a clear bias in how services were provided. Disparate impact, however, introduces a much more complex layer of legal theory because it does not require proof of discriminatory intent. Under this doctrine, a policy may be facially neutral, that is, it applies to everyone uniformly, but it still results in a disproportionately negative outcome for a specific protected class. The evolution of this concept was underscored by the Supreme Court case Texas Department of Housing and Community Affairs versus Inclusive Communities Project, which firmly cemented the viability of disparate impact claims under the Fair Housing Act. This matters because it shifts the focus from the licensee's state of mind to the actual, worldly consequences of their business operations. You might implement a policy intended to be objective or efficient. Yet if that specific rule creates a significant barrier for a protected group, you could face litigation for failing to address that impact. The rationale behind this is that systemic discrimination can perpetuate inequality just as effectively as prejudice can, and the law seeks to identify and remediate these barriers regardless of whether the business owner personally harbored a grudge or intended to harm anyone. Consider the practical implications of a blanket, no criminal record policy, which is a common example used in legal textbooks to illustrate disparate impact. A landlord might implement this rule simply because they want to ensure safety and stability within their rental properties, which sounds reasonable on its face. However, statistical data shows that certain protected classes are significantly more likely to have contact with the criminal justice system in many jurisdictions, meaning this policy could disproportionately exclude those individuals. By creating a barrier that affects one group much more severely than others, the landlord needs to be able to show that the policy is necessary to achieve a legitimate business goal. If there is a less discriminatory way to satisfy that goal, the policy likely fails the legal test and constitutes an illegal practice under the Fair Housing Act. Licensees and managers must be prepared to defend their operational rules not just by stating they are neutral, but by demonstrating that they are essential and that no alternative approach would serve the purpose without the negative impact. Another common scenario involves minimum income requirements that might be set at a level that inadvertently excludes single-parent households or larger families. These requirements are usually designed to protect the property owner from potential default, which is clearly a valid business interest, but the methodology used to calculate this impact is under constant scrutiny. When professional licensees design their intake procedures or their office policies, they must evaluate them through the lens of unintended consequence to ensure they are not acting as unintended gatekeepers. It is not enough to say that you apply the same rule to everyone if that rule effectively locks out a specific protected class unnecessarily. A nuanced approach involves identifying when a policy might have a chilling effect and proactively adjusting it to be more inclusive while maintaining the necessary standards for financial safety. This level of awareness is a requirement for modern real estate practice, as the legal standard is not merely about checking boxes for neutrality, but ensuring that the impact of those boxes does not run afoul of civil rights. Mastering these distinctions will serve you well when you are faced with complex exam scenarios where you must determine the legality of a specific house policy. Keep these legal definitions in mind as we conclude this section. See you in the next lecture. Welcome to this session on the Americans with Disabilities Act, a federal statute that sits adjacent to, but is distinct from, the housing laws we have previously discussed. It is a common point of confusion for students to conflate the Fair Housing Act with the Americans with Disabilities Act, or ADA. While the Fair Housing Act focuses on residential dwellings and the rights of tenants and buyers to secure housing, the ADA Title III is concerned with commercial spaces and public accommodations. A real estate brokerage office, if it is open to the public, must comply with the accessibility requirements dictated by the ADA. This means that if you operate a brick-and-mortar office or use a model home to conduct business with prospective clients, you are functioning as a place of public accommodation. Your adherence to these standards is not merely a matter of professional conduct, but a legal requirement to ensure that individuals with disabilities are not denied access to your services based on the physical design of your facility. When we consider existing structures, the ADA requires the removal of architectural barriers where such changes are readily achievable. Readily achievable is defined in the statute as something that can be easily accomplished and carried out without much difficulty or expense. This might include installing an inexpensive ramp over a small step, rearranging furniture to widen an aisle, or installing grab bars in restrooms. However, if a modification requires significant structural changes that would be prohibitively expensive or technically infeasible, the law provides a measure of flexibility. It is not an absolute mandate to renovate every square inch of an old building, but rather a mandate to provide reasonable access whenever it is fiscally and physically feasible to do so. These obligations shift significantly, however, when you move into the realm of new construction or substantial renovations. For buildings constructed or altered after the effective date of the ADA, the law requires strict adherence to the Americans with Disabilities Act accessibility guidelines. Unlike the flexible standard for existing buildings, new construction must be fully compliant from the ground up, incorporating precise engineering specifications. We are talking about specific measurements, such as clear doorway widths of at least 32 inches, ramp slopes that do not exceed a 1:12 ratio for safe, independent travel, and the designation of specific accessible parking spaces located as close as possible to the primary entrance. Financing institutions and retail real estate branches have no exemption from these requirements, as they serve as vital hubs for commerce. Failing to maintain these standards creates a barrier to entry that is strictly prohibited by federal law, regardless of the size of the brokerage. Understanding the distinction and applicability is essential for your exam success and your professional practice. If an individual is attempting to access a residential home you have listed for sale, we look to the Fair Housing Act to determine the legality of physical modifications or reasonable accommodations requested by that person. If that same individual is attempting to walk into your office to sign a contract, the ADA dictates how you must provide access to your business space. The exam will frequently test your ability to categorize a scenario based on where it takes place, whether it is in a private residence or a place of public accommodation. Maintaining this mental separation between commercial regulation and residential housing law will help you navigate these questions with the necessary precision and technical accuracy. See you in the next lecture. Hello. In this lesson, we are going to explore the intersection of professional ethical standards and the legal mandates governing fair housing. To understand the professional landscape, we must first recognize that the law establishes a floor, while ethical standards establish a ceiling. Federal fair housing laws, such as the Fair Housing Act, dictate what you must do to avoid legal liability and civil penalties. However, your role as a licensed professional often requires adherence to higher standards, such as those found in the National Association of Realtors Code of Ethics. Article 10 of this code is particularly significant because it explicitly prohibits realtors from denying equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. While a court of law might ask if your actions violated the Fair Housing Act, An ethics committee will ask whether you upheld the dignity and equality expected of the profession. This distinction is crucial because you can theoretically follow the letter of a law while still violating your professional duties. Professional integrity requires a commitment that goes beyond merely avoiding a lawsuit or a fine. By aligning your practice with these higher standards, you protect the reputation of the industry and foster a more inclusive market for all participants. Understanding this synergy is the first step toward becoming a truly competent and ethical practitioner who commands respect in a marketplace. The equal professional service model provides a mechanical, yet essential, framework for ensuring that your behavior remains consistently neutral and ethical, regardless of whom you are serving. The core idea is to standardize every interaction to remove the possibility of implicit bias or inconsistent treatment. When you implement this model, you follow the same steps for every inquiry, from the initial phone call to the final closing document. For example, if you provide a specific packet of information about local schools and taxes to one client, you must provide exactly the same information to every other client. If you require a buyer to provide a pre-qualification letter before showing property, that requirement must be applied universally without exception. This systematically eliminates the risk of steering or unequal treatment that often arises when agents make subjective judgment calls. You should think of this as a defensive system that prevents you from accidentally offering different levels of effort or consideration based on a client's appearance or background. It allows you to focus on your professional task, the conveyance of property, rather than inadvertently filtering your efforts through personal perception. By standardizing your workflow, you transform fair housing from an abstract legal concept into a tangible, measurable, and repeatable business process. Documentation and rigorous record-keeping serve as the bedrock of your defense against potential discrimination claims. In a professional setting, relying on memory is insufficient because a documented history of your interactions is the only reliable evidence if you are ever accused of bias. You should maintain detailed logs of every client interaction, including dates, the specific property information shared, and the reasoning behind any decisions made during the buying or selling process. If a client from a protected class requests to see a specific neighborhood where you perhaps suggested a different area, your records should clearly indicate the data-driven reasons, such as budget constraints or specific property features, that guided your advice. If you can produce a log showing that you treated a client exactly as you have treated every other client, you are in a significantly stronger position to refute allegations of disparate treatment. Furthermore, consistent documentation creates a culture of accountability within your practice, discouraging any deviation from ethical standards. Remember that regulators and civil rights testers are not merely looking for evidence of intent to discriminate, but are also looking for patterns of inconsistency. A well-maintained file is not just administrative overhead. It is tangible evidence of your professional conduct and a safeguard for your career longevity. Ultimately, the integration of these ethical codes with federal law is what separates a knowledgeable agent from a high-quality advisor. When you encounter complex scenarios on the exam, you must look for the answer that demonstrates both legal compliance and the highest level of professional care. The material you learn regarding ethical conduct builds a bridge between the prohibited actions defined by law and the proactive behaviors required by industry best practices. It helps you recognize that fairness is not about treating everyone the same in a vacuum, but about actively creating a level playing field through standard processes. This alignment is what builds trust with the public and ensures that the real estate industry functions with the efficiency and fairness it promises to the community. When students understand that ethics are a professional asset rather than a regulatory burden, they approach their career with a different mindset. By viewing the code of ethics and federal law not as separate entities, but as a singular requirement for your practice, you prepare yourself for the nuances of real estate regulation. Focus on these connections as you continue your study, as they will serve you well in both the testing center and the field. See you in the next lecture. Welcome. In this session, we will shift our focus from memorizing statutes to mastering the art of deconstructing the complex, story-based scenarios that define the national real estate exam. When you encounter a long-form question on your exam, the initial temptation is often to read it word for word and try to mentally act out the scene. This is a common trap that leads to cognitive overload because the narrative often contains irrelevant details designed to distract you from the legal principle at stake. Instead, I suggest you adopt a systematic decomposition strategy where you strip away the prose to reveal the underlying mechanics of the situation. Start by identifying the primary actor, which is the person or entity taking the action, and then determine if that actor is subject to the Fair Housing Act. Once the actor is established, isolate the protected class, or lack thereof, to see if the behavior targets a specific group or if the scenario is a neutral event disguised as something more sinister. A frequent complication in these scenarios is the presence of what I call red herrings, which are details that trigger an emotional or moral response but hold no legal weight. For example, a question might mention the race or religion of a party involved in a transaction, but if the actual action taken, such as a refusal to rent due to a lack of creditworthiness, does not stem from that identity, the protected status is legally irrelevant. You must practice isolating the action itself and asking whether that specific behavior constitutes a refusal to lease, a discriminatory term, or an illegal inquiry. If the information provided does not shift the legal outcome of the scenario, categorize it as noise and focus your attention entirely on the causal link between the actor and the outcome. The most critical part of any long-form question is the call of the question itself, which is the final sentence that dictates exactly what you are being asked to solve. Many students make the mistake of attempting to solve for ethics or general fairness, whereas the exam is strictly concerned with whether the Fair Housing Act has been violated, whether an exemption applies, or whether a specific procedural mandate was ignored. You should read the call of the question before you digest the scenario, as this frames your search for the necessary facts. By knowing whether you're looking for an exception to the law or a prohibited practice, you can filter the incoming information as you read the narrative. When dealing with multiple characters, it helps to map the interactions to ensure you do not conflate the responsibilities of a broker, a homeowner, or a property manager. The law treats individuals differently depending on their capacity, particularly when exemptions to the Fair Housing Act come into play. If a scenario involves a homeowner acting on their own behalf versus an agent acting on behalf of a client, the liability shifts significantly. By maintaining this distinction, you avoid applying broad rules to narrow situations where personal property rights might be protected. Think of your analysis as a dependency graph where the outcome depends entirely on the roles and the specific governing rules applied to those roles. Finally, remember that the exam writers often use these scenarios to test your ability to distinguish between disparate treatment and disparate impact. An overt action of steering, where a real estate professional directs a client toward or away from a neighborhood, is a clear-cut case of overt discrimination. However, a harder question might involve an occupancy standard that seems neutral on its face, but creates an exclusionary effect for families with children. As you work through these examples, practice identifying whether the harm was intended through direct behavior or if it was an unintended consequence of a policy. This level of decomposition ensures that you remain objective regardless of how convoluted the narrative may appear. I will see you in our next session. Hello. In this session, we will examine the influence of implicit bias on professional conduct and how it affects the fair delivery of real estate services. Implicit bias refers to the unconscious attitudes, stereotypes, or associations we hold towards certain groups of people, which manifest automatically and outside of our conscious awareness. Unlike explicit bias, which involves intentional and conscious prejudice, implicit bias can affect the behavior of well-intentioned professionals who genuinely believe they're treating everyone equitably. If you operate on the assumption that a specific neighborhood is a better fit for a client based on their demographic background rather than their stated financial or lifestyle criteria, you are engaging in a form of silent steering. This behavior is insidious because it often feels like intuitive service or helpful filtering, but in practice, it restricts property access and reinforces historical patterns of segregation. In the context of a national real estate exam, recognizing these subtle triggers is essential for identifying potential violations of fair housing principles. You must understand that even without an explicit directive to discriminate, providing different tiers of service based on subconscious categorization constitutes a breach of the standard of care expected from a licensed professional. The manifestations of implicit bias often emerge in the appraisal, lending, and general sales processes through the subtle weighting of non-objective data. For instance, an agent might unconsciously spend more time researching investment opportunities for clients who match their own background, while providing only basic, automated property lists to others. Similarly, in the appraisal industry, there have been documented instances where an appraiser unconsciously assigns a lower value to a property simply by observing the occupant's personal items or demographic indicators, rather than focusing exclusively on comparable sales and structural condition. Lending decisions can also be compromised if a loan officer applies a more rigorous level of scrutiny to the supporting documentation of minority applicants, while taking the financial representations of other applicants at face value. These actions, while perhaps not born of malicious intent, directly contribute to disparate treatment. They create a landscape where the quality of professional assistance is tied to the client's identity rather than their individual objective requirements. To combat these tendencies, HUD and various professional organizations emphasize the necessity of rigorous self-awareness and the implementation of standardized operational protocols. The primary goal of de-biasing your practice is to remove the opportunity for subjective judgment to influence your professional performance. You should adopt the habit of using standard, written intake forms for every single client, regardless of your personal impression of their financial status or background. By ensuring that every client receives the same range of property options based on their explicit criteria, such as square footage, school district proximity, or budget, you neutralize the risk of steering. Furthermore, professional conduct must be anchored in hard data, such as market statistics and MLS printouts, rather than neighborhood reputation or anecdotal hearsay. When you rely on documented objective facts, you minimize the room for unconscious bias to shape the trajectory of a real estate transaction. Ultimately, the National Real Estate Exam is moving toward a competency-based model that prioritizes your ability to navigate complex, diverse environments with consistent fairness. You will likely encounter scenario-based questions that test whether you can recognize when a professional's behavior crosses the line from helpful guidance into discriminatory steering. If you consistently apply the same rigorous, data-driven approach to every client, you will find that you are providing a better quality of service and shielding yourself from potential liability. Fair housing is not merely a legal compliance exercise. It is the fundamental framework of a functioning, equitable real estate market. Treating the public with genuine equity requires a constant audit of one's own decision-making processes. By staying vigilant against the subtle, often invisible mechanisms of bias, you protect the integrity of the profession and ensure that all participants have equal access to the housing market. I will see you in the next lecture. Welcome back. In this lesson, we examine the practical application of fair housing laws specifically within the context of property management, where the risk of liability is statistically highest. Property management is a high-stakes environment because every decision you make regarding a tenant acts as a potential evidentiary record for a fair housing complaint. You must view your operational policies not just as business practices, but as legal instruments that require strict, uniform application to every single applicant. When we discuss screening criteria, the standard is consistency. If you require a specific credit score or a particular debt-to-income ratio, that benchmark must be applied to every applicant without deviation. Allowing exceptions for one individual while enforcing rigid standards on another creates a textbook case for a fair housing violation based on disparate treatment. It is better to have a slightly flexible policy that is applied to everyone than a rigid policy that you selectively waive. Your application fees and security deposits should likewise be standardized and transparent. Never alter these figures based on personal assumptions about an applicant's financial stability or character. Providing a written, objective list of screening requirements to every prospective tenant acts as your primary layer of defense in any future audit or investigation. The issue of service animals often generates unnecessary friction, yet the legal requirements are quite precise. If you manage a property with a strict no-pet policy, you must understand that service animals and emotional support animals are not considered pets under the Fair Housing Act. These animals are tools that provide necessary assistance to individuals with disabilities, and thus, a request for a reasonable accommodation must be handled with care. You cannot charge a pet deposit or monthly pet rent for a verified service animal, as doing so would constitute an illegal surcharge for a protected class. Furthermore, you cannot deny an applicant simply because of the presence of an assistance animal. If an applicant requests an accommodation, your role is to verify the disability-related need if it is not readily apparent, not to challenge the animal's presence as a lease violation. Policies that attempt to limit the breed or weight of service animals typically fail under federal scrutiny. Always document the interaction and the basis for your approval or denial of the accommodation request to demonstrate that you followed a deliberative, non-discriminatory process. Familial status protections create specific obligations regarding common areas like pools, gyms, and playgrounds. You cannot restrict children from using these facilities or impose rules that effectively segregate residents with families from the rest of the community. For instance, any rule that limits pool access based on age, such as banning children during specific hours, is almost certainly a violation of federal law. If you have safety concerns, those concerns must be based on legitimate, objective facts rather than generalized assumptions about children behaving poorly. The goal of the Fair Housing Act is to ensure that families with children receive the same enjoyment of the property as any other household. Arbitrary rules often masquerade as safety measures, yet in practice, they function as barriers that exclude families from full residency. Review your property rules frequently to ensure that they do not disproportionately affect households with children. When management creates an environment where families feel unwelcome, the law views this as a failure to comply with the fair housing mandate regarding protected classes. Tenant screening also brings the Equal Credit Opportunity Act into play, which prevents discrimination in credit-related decisions. When a management company pulls credit reports, you are participating in a financial evaluation that must remain completely neutral. You simply cannot select specific credit bureaus or criteria based on the perceived economic status of a particular group of applicants. Any denial of a lease application must be supported by a clear, written record of why the criteria were not met. This record should explain the specific policy or financial threshold at issue, removing any room for subjective interpretation or bias. If you decline an application, provide the adverse action notice promptly and ensure that the reason for denial is identical to the reason cited in your internal records. Keeping a thorough paper trail of every interaction, from the initial inquiry to the final decision, is your best protection against spurious complaints. Relying on gut feelings or personal impressions is not only unprofessional, it is the most common path to a fair housing enforcement action. See you in the next lecture. Welcome back, everyone. Today we are unpacking the Equal Credit Opportunity Act, or ECOA, and specifically how it intersects with the fair housing principles we have already established. In the world of professional real estate, keeping your regulatory framework straight is essential for passing the national exam. While we are very familiar with the 7 protected classes under the Fair Housing Act, the Equal Credit Opportunity Act shifts our focus specifically to the financing and credit side of the transaction. Think of the Fair Housing Act as the rulebook for buying, selling, and renting, while the ECOA acts as the primary safeguard for anyone applying for a mortgage or property loan. These two laws are distinct, yet they overlap in their commitment to preventing discrimination, making it common for test questions to challenge your ability to distinguish which law applies in a specific lending context. The core purpose of the ECOA is to ensure that all applicants are given an equal chance to obtain credit, regardless of specific personal characteristics that lenders might otherwise use to filter out or penalize borrowers. The ECOA expands the reach of protected categories beyond what you see in typical housing statutes to include age, marital status, and the receipt of public assistance. It is a frequent point of confusion that while a landlord is governed by the Fair Housing Act, a mortgage lender is almost exclusively tethered to the mandates of the ECOA when evaluating an application. For instance, consider a borrower who is a widow or a retiree relying on Social Security. The ECOA explicitly prohibits a lender from using these factors as a basis for denying a loan. If you are reviewing a scenario on the exam where a lender asks about a borrower's plans to have children or denies an application because of the source of income from a public assistance program, you are immediately dealing with an ECOA violation. This act forces lenders to treat every applicant as an individual based strictly on their creditworthiness and ability to repay the debt, rather than on personal attributes that have no bearing on financial capability. Beyond the primary protected classes, the Act mandates operational transparency that directly benefits the consumer during the loan process. One of the most important elements you must remember is that borrowers have a statutory right to receive a copy of any appraisal report used during the underwriting process. This disclosure requirement ensures that the applicant is fully aware of the valuation conclusions that might impact the final approval of their mortgage. Furthermore, the ECOA requires that if a lender denies a credit application, they must provide the applicant with a clear and specific reason for that denial. You cannot simply turn someone away with a vague explanation, as the law demands accountability and clarity so that the consumer understands exactly why they did not secure the financing. Failing to adhere to these notification procedures is just as much a violation as active discrimination during the assessment phase. When we look at the interaction between these laws, we see a layered system designed to protect the integrity of the market from the initial house hunt all the way to the closing table. If you maintain a firm understanding of which protections belong to the Fair Housing Act and which are unique to the ECOA, you will be much better prepared to untangle complex exam scenarios. Remember that age, marital status, and public assistance are the key identifiers for ECOA, while race, color, religion, national origin, sex, disability, and familial status continue to be the pillars of fair housing. By compartmentalizing these regulations, you avoid the trap of applying the wrong rule to the wrong party, which is exactly the kind of test-taking mistake that leads to lost points. Keep this distinction at the forefront of your mind as we move through the remaining administrative and practical components of our prep plan. I will catch you in the next lesson. Welcome to our session on the formal requirements for documentation within the real estate profession. We will explore the specific administrative obligations that serve as the foundation for transparent and compliant agency practice. When we discuss the proper usage of disclosure forms, we must first address the physical environment where professional services occur. Federal law mandates that the fair housing poster be displayed prominently in any place of business related to real estate brokerage. This is not a mere decorative choice, but a fundamental legal obligation under the Fair Housing Act. The Department of Housing and Urban Development, or HUD, uses the absence of this poster as primary evidence of discriminatory intent during investigations. If an inspector enters a brokerage office and finds no such notice, It signals a systemic disregard for federal law that can be used against the licensee. The poster must contain specific visual elements and the text required by HUD regulations to remain valid. You should ensure that the poster is visible to every person who walks through your doors, whether they are a client, a customer, or a general visitor. Maintaining this visibility is a simple administrative step, yet its omission carries significant legal and financial consequences for your business operations. Beyond posters, the distribution of the HUD Fair Housing Pamphlet is a core component of your professional toolkit. This pamphlet provides clients with a roadmap of their rights and your duties under the law. It serves the dual purpose of educating the consumer and establishing your initial position on compliance. However, you must avoid the common temptation to view the distribution of these forms as a get-out-of-jail-free card. Providing these documents does not immunize you from the consequences of discriminatory behavior, nor does it replace the requirement for consistent, equitable conduct. If you hand out a pamphlet but then engage in unethical practice, the delivery of the form provides no protection in a court of law. It is merely a procedural baseline that allows you to demonstrate your adherence to standard operational requirements. Treat these disclosures as the starting point for your client relationship, confirming that all parties are operating under the same set of federal guidelines from the outset. A critical application of these disclosure requirements arises when a seller attempts to exert inappropriate control over the transaction by requesting we exclude certain buyers. If a seller instructs you to only target or accept offers from a certain type of person, you are witnessing a direct violation of federal law. As a licensee, your response must be immediate and unambiguous. You must refuse to follow such instructions. It is your professional duty to explain the legal requirements for non-discrimination to the seller clearly and firmly. You must document that you have performed this action, as this record can prove vital if the seller later initiates a complaint or an investigation occurs. By refusing to comply with discriminatory requests, you are upholding your ethical obligations and the fiduciary duties you owe to the public. If a seller persists, you should consider terminating the listing agreement, as you cannot fulfill your representation duties while violating the Fair Housing Act. Mastering these protocols ensures you operate with a clear understanding of your professional boundaries. See you in the next lecture. Welcome to our deep dive into the specific vocabulary that defines the regulatory landscape of fair housing. Understanding these terms is quite similar to learning a new language where precise definitions serve as the foundation for your eventual professional conduct. In the legal world, prima facie serves as a foundational concept, meaning that a fact is presumed to be true at first sight unless sufficient evidence is provided to refute it. When a fair housing complaint reaches a hearing, the plaintiff must often establish a prima facie case to suggest that discrimination has likely occurred. Moving to the enforcement side, you will encounter the term conciliation, which refers to the administrative process of resolving a complaint through a mutual agreement rather than a formal trial. This is a voluntary effort to reach a settlement, often facilitated by an agency like HUD, to avoid the high costs and uncertainties of litigation. Should conciliation fail and a violation be proven, a court may issue an injunction, which is a judicial order that forces a party to stop a specific harmful activity or, alternatively, to perform a required action. Understanding the distinction between these terms is vital because they delineate the life cycle of a legal claim from the initial accusation all the way to the final judicial remedy. The term testers is frequently misunderstood, yet it is quite simple. These are individuals tasked by regulatory agencies to observe and report on whether housing providers treat all applicants equally. They pose as prospective tenants or buyers to elicit information about whether agents are engaging in prohibited conduct or following fair housing standards. When we discuss illegal behavior, blockbusting often appears in scenarios involving real estate agents creating panic among homeowners by suggesting that the racial or ethnic composition of a neighborhood is changing. The goal of this illegal tactic is to induce homeowners to sell their properties at depressed prices out of fear, which the agent then profits from during subsequent resales. Conversely, redlining is a term you should immediately associate with lending and insurance practices, specifically the refusal to offer services or the charging of higher premiums in specific geographic areas based on protected class characteristics. Both acts are egregious violations that strike at the heart of equal opportunity in housing. Steering is perhaps the most common violation you will encounter, and you should always associate this term with the act of guiding buyers toward or away from specific neighborhoods based on their protected status, rather than showing a prospect all available homes that fit their financial requirements. An agent might choose to show homes only in areas where people of similar national origin live. This denies the buyer their right to choose where they live freely and undermines the integration of our communities. We must also address the legal concept of familial status, a protected class under the Fair Housing Act designed to prevent discrimination against families with children under the age of 18. This protection also extends to pregnant women and people in the process of securing legal custody of children. Failing to understand that a property cannot be restricted based on the presence of children is a common pitfall on the national exam. So anchor this term firmly in your knowledge base. Finally, we arrive at the topic of reasonable accommodation, which refers to a change in rules, policies, or practices that is necessary to allow a person with a disability the full use and enjoyment of a residence. A standard example is a landlord waiving a no-pets policy to allow a tenant to keep a service animal, as this is a modification of a rule rather than a physical change to the structure. Distinguishing these from physical modifications allows you to see how the law accommodates different needs through either procedural flexibility or structural renovation. Many candidates lose points by confusing these concepts, so always view a reasonable accommodation as an adjustment to a housing policy. By mentally linking these definitions to their functional outcomes, you'll be much better prepared to interpret the exam questions when they arise in a timed environment. Memorizing these definitions as discrete units is far less effective than understanding how each term relates to the enforcement of fair housing law and practice. I will see you in the next lecture. Welcome back. This final session serves to synthesize the legal progression of fair housing law and ensure your exam strategy is perfectly refined. To understand the trajectory of American housing law, we must view the legislative acts not as isolated events, but as a continuous evolution toward equality. The Civil Rights Act of 1866 laid the bedrock by prohibiting all racial discrimination in the sale or rental of property, providing no exemptions. This was followed by the landmark 1968 Fair Housing Act, also titled Title VIII, which initially protected race, color, religion, and national origin. We then saw the 1974 amendment add sex to the list of protected classes, which was a vital correction to the previous oversight. Finally, the 1988 Amendments Act rounded out our current federal framework by adding individuals with disabilities and familial status to the protected categories. When you encounter a question regarding the timeline or the specific protections of these acts, visualize them as a building where each layer provides more stability and broader coverage than the one beneath it. The 7 federally protected classes remain the cornerstone of your exam knowledge, and you must hold them in active memory at all times. Remember the acronym often used for these classes: race, color, religion, sex, handicap, familial status, and national origin. Distinguishing between illegal conduct is equally critical, as these terms are frequently tested through scenario-based questions. Steering involves the subtle or overt act of guiding individuals toward or away from specific neighborhoods based on their protected class. Blockbusting targets the seller's fear, inducing panic selling by suggesting that the entry of a protected group will diminish property values or neighborhood quality. Redlining operates at the institutional level, where lenders refuse to provide financing or offer disparate terms based on the geographical location of a property, usually with the intent of discriminating against inhabitants of specific areas. Keep these definitions distinct, because the exam will present scenarios designed to blur these lines. Enforcement of these laws follows a specific, predictable path that you should be able to recite mentally. When a complaint is filed with the Department of Housing and Urban Development, the agency has a limited investigative window, generally within 1 year of the alleged discriminatory act. If the situation proceeds to federal court, the statute of limitations typically extends to 2 years for private civil suits. Understanding this distinction is vital because a question might ask whether a HUD administrative process or a direct federal lawsuit is the appropriate remedy within a specific time frame. Always remember that the burden of proof initially rests with the complainant to show a prima facie case of discrimination, after which the burden shifts to the respondent to provide a non-discriminatory justification for their actions. Regarding your exam day strategy, the most effective approach is the deliberate use of the elimination method for every multiple choice question. Do not scan for the right answer immediately. Instead, read the entire prompt thoroughly, paying close attention to words like except or always, which often flip the context of the question. Once you identify the requirements of the prompt, systematically eliminate the 2 options that are clearly incorrect, even if they seem plausible at first glance. This reduces the problem to a binary choice, increasing your statistical probability of success and preventing the common mistake of choosing a distractor answer that sounds correct but is contextually irrelevant. Maintain a steady pace throughout the session, and if a question presents a complex scenario, draw a small diagram of the parties involved to keep the relationships and legal duties clear. Internalizing these fair housing principles goes far beyond the requirement for passing a standardized test. As a real estate professional, you're the frontline defender of the principles of equal access to property. When you anchor your practice in these ethical foundations, you protect the rights of every citizen to seek housing without the barriers of historical prejudice or systemic bias. This commitment is the primary indicator of a career defined by integrity and long-term success. You are now equipped with the knowledge required to navigate these regulations with confidence and precision. See you in the next lecture.